still watching it for pizza and beer. Not that there's anything wrong with that.
Nobody else comes to down here, right?
Well, that's it.
You have to get up and say something. I'm trying to talk Joanne into sitting right there. Well, she wasn't too excited.
We wait on Joe.
He's here on the phone.
Sometimes I don't hear.
Rita, whenever you're ready.
It seems like I miss it. But then I check.
We're almost there. You bet my trip up.
So we should probably read it.
Pardon me?
It could be catastrophic. The wrong ambulance lost.
Yeah, really.
Both could have Delta Day.
We don't have to read it in the record, but I think we can.
If you want.
You need to turn your mic on. You're up. I can tell from here. Yes. Everybody needs
Do you have this?
No, I don't think so.
Give that
If
back.
it was, I don't know why that happened, I would be in a time here.
All right. Would you just keep it in your place?
Yes.
Thank you.
What's your name, ma'am?
Natalie Marshall.
Natalie, spelled M-A-T-A-L-I-E. And your last name?
Marshall.
2 L's.
Yes, ma'am.
And you want?
Secretary.
We can go.
Let's call this meeting to order.
One
Please
second.
stand and pledge the flag.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Rita, would you call the roll, please?
Commissioner Stanley?
Here.
Commissioner White?
Here.
Commissioner Northline? Here. Mayor Morgan?
Here.
Commissioner Ganger? Here. Let the record show that Commissioner Ganger and Mr. Drescher are with us today by phone. And we have Mr. Randolph on the dais.
We've been provided with the minutes from the public hearing of September 12th, 2014, as well as the tentative budget hearing that same day, and the final budget hearing of September 23rd. Are there any corrections or additions? If not, is there a motion to approve?
Move for approval of the minutes.
Second.
Who said second?
Commissioner White.
Thank you.
Commissioner Stanley?
Yes.
Commissioner White?
Yes.
Commissioner Northline?
Yes.
Commissioner Ganger? Yes. Mayor Morgan?
Yes. Any changes to the agenda items?
I'd like to make one change. I would like to have item 10A2 heard at a time certain of 9:45.
Item 10A2 will be moved after the public hearing and considered at approximately 9:45. Our next meeting is November 14th. Anyone who can't make that meeting, please mark it on your calendar. Public communication, would anyone care to speak? 5-minute limits. Mr. O'Hare.
Thank you, Mr. Mayor, members of the commission. You adopted the minutes from the public hearing, but I noticed there were discrepancies in the minutes between what was written down and what actually happened. Specifically, I had question the 3% raise for Mr. Thrasher in the final budget, which was previously an 8% raise for both salary and benefits. The minutes reflect that Commissioner Stanley said that that was the same in both budgets, and it was actually 8% to begin with, and it was reduced by 5%. Also, I had made a comment regarding the town paying more money in legal fees to fight some of these small claims against the town than it would cost to resolve those claims. And the minutes say that just the opposite, that I said it was less for the town to spend money on legal fees. So I'd like to submit that the minutes are a little bit inaccurate. I did want to ask or speak to one other issue on the budget. I went back over it after hearing the commission's comments with the few items I had raised, and it seems a lot of money is parked into places where there's no intention of ever spending it there. $2,000 for the town library, $75,000 for water management fees, and it occurs to me that this is just a way to park money that will then be shifted into legal fees next year. Because it seems to me on the budget, the amount of money allocated for legal fees is less than the town spent in the month of July. So obviously you're way short on legal fees for next year. And I'm thinking the intention is really just to shift the money from these faux places to legal fees in the future. One last item. The town had an emergency meeting to discuss handicap ordinance, this thing called a reasonable accommodation. I spoke against that because it provided for 7 months of approval process for a handicapped person to get accommodation to their home. And I felt, at the next meeting I said I felt foolish because Mr. Morgan had stated, well, that was really about the sober houses. And I spent all that time talking about it and it was silly. So now we hire counsel in regard to the sober house ordinance, and I'm just wondering, I hope you discuss it later and explain why, even though the ordinance is now adopted, that counsel has to be hired. Is there someone suing the town over our sober house ordinance? I just hope the commission will address that later in the meeting. Thank you.
Thank you, Mr. O'Hare. Let's move to the public hearing.
Excuse me.
I'm sorry. Nancy, I didn't mean to cut you off.
Well, yeah, did. My name is Patsy Randolph. As I've done in the past, I'm once again voicing the concern of Gulfstream residents over the town's financial health and its morale. To put this concern in perspective, I will refer to Mayor Morgan's June 14th letter, which was extremely informative and well received by the community. Mr. Mayor, we hope you will continue to send out similar reports. I quote, "Current thinking is that a reasonable general fund reserve for a town of our size should be around $1 million to $1.5 million. And that is a level that Gulfstream has typically maintained. Recently, Gulfstream's general fund reserves have dropped to around $675,000. Legal fees and costs have risen dramatically due to our defending over 20 lawsuits filed by 2 residents, Mr. O'Boyle and Mr. O'Hare. These lawsuits are primarily public record actions and relate to over 800 public records requests filed by these 2 residents or by other individuals and organizations with whom they appear to be connected. The records requests involved many thousands of documents that, in my opinion, have little purpose other than to harass and financially damage our town. To put the legal fees in perspective, Gulfstream typically budgets around $15,000 annually for legal services. In the first 6 months of this year, we've already spent over $160,000. Those dollars have come from somewhere by reducing budgeted allocations for other services or tax increases or from the town's reserves." End of quote. Let me repeat. The town typically budgets $15,000 annually for legal services. But yet, for the first 6 months of this year, the town's litigation fees have been over $160,000 to handle Mr. O'Boyle and Mr. O'Hare's lawsuits that are apparently meant to harass and financially damage our town. This is outrageous. But that's yesterday's facts. I can only imagine that this continued onslaught has raised these numbers substantially. It is important and critical for us to be kept up to date as to what these two individuals are costing our town. And we suggest and want a year-to-date numbers to be put on the town's website, and that these numbers be revised monthly. After all, it's our money. We're the taxpayers. I also want to reemphasize the community's repulsion over the continued harassment of our town. We are appalled by signs with crude, immature, baffling language that pollute our skies and local streets. We are sickened by the inappropriate behavior of a resident towards the town's female employees. Let me quote from a letter obtained through the public records request process from Mr. Thrasher to Mr. O'Boyle. I have received complaints on several occasions, whether intentionally or otherwise. You have caused disruption of employees' work activities and have engaged in contact with female employees, which they deem to be inappropriate, causing them to be uncomfortable. Therefore, please be advised as follows. Please do not touch any of the female employees in any manner. This includes handshakes, hugs, arms around the shoulders, kissing, or any other similar uninvited activity. End of quote. In closing, let me make something very, very clear. Gulfstream residents are fed up. They are angry. There is no longer apathy in Gulfstream. Remember our recent town election, the largest turnout ever in Gulfstream. We strongly support your efforts to fight these attacks on our town and recognize that this will be costly, but it is necessary and important for the town to continue to stand strong. Thank you.
Thank you. Anyone else care to speak? If not, then let's move on to the public hearing. This is an application by Mr. Jones, agent for 3140 Polo. Before we do that, any ex parte communications? Commissioners?
I run by the site periodically. I'm Pat Charlie, other than that, none.
None? Rita, would you swear in the witness?
Anyone that intends to speak at this public hearing, please stand and raise their right hand. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, Mr. Jones.
Thank you. Good morning,
Good morning.
Mr. Mayor, City Commissioners, General Public. It's a great Friday. My name is Richard Jones, and I'm an architect in Delray Beach, and I'm very excited to present this project before you this morning. 3140 Polo Drive. I have to apologize, the developer and landscape architect are not able to make it this morning. Be happy to answer any questions on their behalf. The developer, I'm sure you are familiar with, Mr. Downey with Seaside Builders, who is the developer of the Harbor View project, which I might add has been very successful. 5 of the 6 homes are already sold and nearing completion. So thank you very much for your support on that project. 3140 Polo Drive. You see a rendering before you on the screen. A classic Gulfstream Bermuda style home of modest size. If we take a look at the location, Polo Drive at 3140, direct access to the canal that leads to the intracoastal subject property there highlighted. We go to the site plan, and I apologize that some of these images are a little light. I know that you have the package in front of you. One thing you'll notice about this particular lot is its size. It's actually smaller than the minimum standard lot size in the ocean or in the Gulfstream Core District. But as such, a smaller lot would dictate a smaller home, and that's exactly what this one is. Modest house of approximately 3,600 square feet, 2 stories, great room plan, 2-car garage, a lot of stepping on the facade. The second story, quite a bit reduced in size, just a few bedrooms and a little loft area and open balcony. And the elevations before you, again, very pleasing, very compatible and complementary to the existing homes on the street. A white-on-white color palette with navy blue shutters, wood garage doors and front door, and a signature parapet detail that flanks the entry. The house was actually designed to accommodate saving a very large tree. Rita, if you could help me out with the species of that tree. I think Mr. Thrasher is here. I didn't see him up there, but I know he's on the phone. Bill, what was that tree that we designed this house around?
Mr. Jones, I believe it was an avocado tree.
Avocado tree. So it's a large avocado tree on the site, and we accommodated for that in the design of the house. So again, it's a very modest size, a very pleasing elevation, and would be a good fit for Polo Drive. I'd be happy to answer any questions that you may have. If need be, we could possibly, if there's any landscape questions that I cannot answer, now that I know we can use the phone, I might call a friend, actually, the landscape architect.
Any comments from neighbors, complaints that you're aware of, Mr. Jones?
Rita,
Mr. Mayor, I would like to make a statement if I may.
Absolutely. I just wanted to find out from Mr. Jones whether there have been any.
I believe there was one letter that was written, Rita, is that correct?
Not about this particular project.
Okay,
Okay,
then we're not aware of any
okay,
issues.
all right. Sir?
Everyone's sworn in.
Deputy, swear. Rita, just swear in witness.
Would you raise your right hand, please? You swear to tell the truth, whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you, Mr. Mayor. Tony Graziano, 3259 Polo. I don't have any issue with respect to the house and the building. I do want to make a comment about what happens around this town when construction goes on. We have an ordinance that purports to regulate the days and hours that contractors can work. Two comments about that. First, 30, 40 years ago, this was predominantly a snowbird community, but now we have many more people who are here all year round. Yet we allow, during the off-peak season, work to go on Saturdays. And I know for some of our younger residents who work all week long, it can't be a joy to wake up at 8 o'clock on a Saturday morning to have heavy construction going on next door. And I don't know who the neighbors are at the 3140, but I'm sure they will not be happy when construction starts Saturday morning. The second point, and this I have had issue with the town manager, he does what he can. There is no effective enforcement mechanism for requiring contractors to start at 8 o'clock or later, or to cease at 5 o'clock or earlier. A contractor can violate it every single day of the week. You can start at 7, 7:15, 7:30. The only thing a neighbor can do is to call up the police, and if they're not busy doing more important police work, they can come down to the construction site after the neighbor has been awakened at 7 o'clock, and they can shut down construction until 8. Now, I wrote the prior mayor about this a year ago, and I know nothing has been done in terms of changing the ordinance so that we have an effective enforcement mechanism so that you can't be constantly awakened earlier in the morning. Thank you.
Thank you, Mr. Graziano. I'll let you know, I think it's a very legitimate point, the Saturday work hour limitation, because as our town becomes populated more and more with full-time residents, I question whether Saturday work hours really are something that needs to be better restricted, and I will look into that and get back to you on it. As far as enforcement, our town lacks a penalty provision for many of the ordinances in this town. I've been working with the chief and with counsel to put together a provision that that will be feasible, one that will apply to cases like this, so that the ordinance has teeth in it, and the police can actually get some response from the contractors. It's not quite as easy as I thought it might be. I thought we could just slap a penalty provision in the ordinance, but that's not the way it works. But I want to assure you that it's a top priority of mine. Hope to have it done very shortly. Any other questions, Mr. Jones?
One thing that I may add, Rita, has there been any complaints about the hours that the Harborview project has been under construction, if they've been following the rules pretty much with regards to time and Saturdays?
Pretty much.
Okay.
Been going on over a couple of years.
Yes, and so
It's
they've
been
been,
very sparse.
for a few years, I think they've been following the time very diligently, and I see no reason why they wouldn't do so as well on this particular project. Thank you.
I have a comment. It's because the core area where this is being built is a much smaller area with a lot of lawns being damaged because of the construction, and also the number of vehicles, not yours, but the number of vehicles at the end of Polo Drive for a construction site has been ongoing for over a year or so, and it's construction management with the traffic. You're going to have a plan and...
Yes, the developer would be happy to submit a plan.
Okay.
I know they care very much about the cleanliness and what their project sites look like.
Mm-hmm.
And they're very much about safety and keeping the neighbors content, trying to keep the dust down and so forth. So they'd be happy to submit a plan for that.
Okay. It's just the construction traffic has been huge at the end of Polo Drive, and the trucks in the road. It's not yours, but I think there should be some kind of restriction on that. You know, either get the trucks on the property or something, because it causes quite
I believe there was something discussed at the Architectural Review Board about the the traffic and where vehicles would park. Is that correct, Rita?
There was, and Mr.
Yeah.
Ladani indicated, I believe it was Mr. Ladani, that all construction vehicles would be on site, that is on the property.
Yes.
Not on the road.
Correct.
Okay.
Which is what's blocking traffic.
Yeah.
In addition to that, we have property here behind the town hall that can be offered for parking as well.
Okay,
I think
fantastic.
that would be very important to be maintained.
Absolutely.
Keep the trucks off the road.
Not a
Yeah.
problem.
I also saw in the ARPB minutes that there was discussion about the, and some objection to, the deed restriction that the ARPB imposed on the 99 square feet of unenclosed space. Is that still an issue, or is that?
I do not believe so.
Okay.
Yeah, it was 99. There was 2 special exemptions along with this application. We did not touch on those. But one was for the rear setback, and one was for the additional covered area. And I believe the deed restriction was recommended that 99 square feet plus or minus would not be able to be enclosed in the future, and there's no issue with that.
So if we move to recommend approval of that special exception, will include the deed restriction as well.
Yes.
Okay. Any other questions, Mr. Jones?
Richard, can you just talk about the driveway slopes and the drape in the front? On that area of the street, some other projects, I know you've got a little more yard space in the front, but you know, always we're battling with sheet flow coming down the driveway, and then I didn't see where the closest catch basin was. It might be a ways away. I see you've got where is that draining down on the driveway?
Would I be able to borrow one of your?
Yeah, you can take mine.
Sure. Thank you very much. That would be under the civil
Right.
engineer's plan.
Well, there's no deco drain there or anything, which can be quite expensive. You're not required to have one. I just wanted to touch on it. I think you've got plenty of room there, but.
It appears that the driveway is draining to a swale in the front of the property.
Yeah, so you've got
There is about a 8-inch rise, 7 to 8 inch rise from the property line to the driveway. It appears it is pitching towards the swale.
pitching south.
It's pitching south, yes, southeast.
Okay.
Those little lines that you see on the driveway. So that's Likely the reason that there is no drain, deco drain installed at the
Right,
property
okay.
line is because of the pitch to the swale.
And then my only other question about the project itself was, what's behind the parapet on the front elevation? Is it just blank on the other side with the roof there? Is there
There's-
a gutter system or something? or just
Yes, there's
downrange?
oh, here comes Mr. Lavalley now. There's a pitched roof behind the parapet,
Yeah,
and that's a office den in the front. And the parapet itself, could we just enlarge that, if you will? Maybe just go to slideshow from the beginning. There you go. Thank you. Okay. The parapet itself is a, I'll take that if you don't mind, thank you. Bear with us for 1 second as we get back to, try to get back to the front here. Okay. The parapet to the left of the entry is the defining element of the house. It's also picked up in smaller scale with the wing walls that you see to the right of the garage, to the left of the master bath, and there's also 2 projected wing walls on the rear elevation. What's behind there is part of the roof that covers that office area. It would look similar to what's over the garage doors right now if we did not have that parapet, but the parapet actually does make a statement, and it's part of the overall theme of the design. Parapets are very common in Bermuda-style architecture, and there are several examples of them throughout Gulfstream. So, to answer your question, it's just standard roof area behind it.
behind it.
Mhm.
That's all I have.
Anything else, Mr. Jones? Questions from the public? Will entertain a motion?
We have 3 or 4 separate ones here.
Take it from the top.
All right. Any additional comment from the applicant?
No, we're fine, thank you.
Okay. Board discussion, any more? Okay, make a motion. This is an application for development approval, 3140 Polo LLC, 3140 Polo Drive, Gulfstream, Florida, 33483. The first motion is a demolition permit for the site to remove existing structures.
There's a motion to recommend approval of the demolition permit.
I'll second it.
Rita?
Commissioner Stanley,
Yes.
Commissioner White,
Yes.
Commissioner Orthwine,
Yes.
Commissioner Ganger,
yes,
Mayor Morgan,
Yes.
Make a motion for the land clearing permit to clear the property for new construction at the above referenced site.
I'll second that.
Ms. Taylor?
Commissioner Stanley,
Yes.
Commissioner White,
Yes.
Commissioner Orthwine,
Yes.
Commissioner Ganger,
yes,
Mayor Morgan.
Yes. I think you said yes.
Make a motion for to grant the special exception number 1 to permit the reduction of the rear waterfront setback to 37 feet 2 inches.
I'll second.
Rita?
Commissioner Stanley,
Yes.
Commissioner White,
Yes.
Commissioner Orthwine,
Yes.
Commissioner Ganger,
yes,
Mayor Morgan.
Yes.
Make a motion to grant special exception number 2 to permit 99 square foot of covered unenclosed area that exceeds the maximum floor area ratio, subject to a deed restriction limiting the enclosure of the 99 square foot of covered unenclosed area.
Second.
Rita?
Commissioner Stanley,
Yes.
Commissioner White,
Yes.
Commissioner Orthwine,
Yes.
Commissioner Ganger,
yes,
Mayor Morgan.
Yes.
Make a motion to grant a level 3 architectural site plan review to permit construction of a 2-story single-family Gulfstream Bermuda-style dwelling with attached two-car garage consisting of 4,540 square feet and a swimming pool.
Second that?
Rita?
Commissioner Stanley?
Yes.
Commissioner White?
Yes.
Commissioner Orthwyne?
Yes.
Commissioner Ganger?
yes,
Mayor Morgan?
Yes. Thank you, Mr. Jones.
Thank you very much.
Mr. Ladani?
Thank you very much, appreciate it.
Oh, thanks.
Can I get your spelling?
All right, we're now going to move to item 10.2, which is an item of commission action by recommendation of the town attorney. Mr. Randolph?
Are you on 10A1?
Looks like it's 10A. I think Ms. Taylor said it's item
Yeah, that's for the
10A2, but we could
That's for the
just,
945, but I could do the first item.
why don't we do A1 as
Good,
well?
good.
So let's start with that.
Yes, thank you. You have in your packets a curriculum vitae, or several curricula vitae relating to attorneys with the firm of Weiss, Sirota, Helfman, Pastoriza, Cole, and Boniski. I have had conversations with Matt Mandel and Jamie Cole in that firm, and I have advised them in regard to the ordinance that, the fact that the town has passed an ordinance relating to fair housing, which incorporates within that general subject matter sober houses. Because that area is an area within their specific expertise, they're having represented cities such as Boca Raton, Delray Beach, and many other cities, as you've noted in their curricula vitae. I am requesting, because I do not have that expertise, that we retain that firm to assist the town in regard to any matters which may come up in regard to that. There is no existing suit. There is nothing currently on the table in regard to it, but this is a very specialized area, and because it is so specialized and because they have a specific expertise in this area, I would recommend that the town retain that firm, and specifically, but not necessarily exclusive of, Matt Mandel, to assist the town from time to time as needed in regard to fair housing matters. Their governmental rate that they have agreed to charge the town if we were to, if the town were to hire him, would be $250 per hour, which is a very fair governmental rate. I'm happy to answer any questions you may have, but that's basically it. There would be nothing that they would do immediately. I see nothing on the horizon that they need to do, but I would not want to see you put in the position of having something come up and having to respond without having their expertise on board. So I'm recommending that if you see fit, that you retain them. If this is approved, they will send a retainer letter, and it will incorporate the fact that they will work for the town for $250 per hour.
Would you recommend, Skip, that they review our ordinance preliminarily, or is our ordinance a standard form such that they're already familiar with its terms?
They're familiar with it. We can certainly have them take a look at it, but it was really drafted almost verbatim from an ordinance that I believe they prepared for another municipality.
And just so everyone understands, having counsel for this matter is not necessarily just for defending lawsuits. It really goes much beyond that. If you've looked at our ordinance, it has fairly specific standards on how applications are filed and hearings are held, and all of this is new territory for us, and I think we would need guidance from counsel who have experience with it on advising us how to proceed. So that's really the reason I would.
That is, and I'm glad you added that. No, it's not for lawsuits. I was responding to the question that was raised as to whether we have anything pending. No, it is very specific. The ordinance is very specific, and one of the things included within it
is are the duties of the town manager when an application is filed. And I would foresee this law firm assisting the town and assisting the town manager in regard to what his duties and obligations might be in responding to an application. So that's the primary initial reason to hire them, but in the event there were any litigation that arose as a result, I would think that these would also be the people to do that, and I would ask that you encompass your approval of this firm in regard to that type of activity as well. But we'd certainly come to you in the event something like that were to happen to get your final approval in regard to litigation.
Would we contact them directly on any particular matter, or go through Jones Foster first and have you speak?
I think initially go through me, and after an initial contact, we'd probably just hand the whole matter over to them.
Okay. Other questions?
Is there any sum that the town would have to pay, put up beforehand to retain them?
No, I haven't seen a retainer letter, but I don't believe so. And if there is something in the retainer letter that requests that, I would bring that back to you. But at this point in time, my feeling is to just authorize hiring them at $250 an hour for any work needed that falls within their expertise.
No other questions? Is there I guess we should do this by way of motion.
Yes, please.
To authorize the town to retain this law firm.
Make a motion for the town to authorize to retain Weiss Sirota Health and RICO and Atheist special counsel with regard to the items stated by the town attorney, subject to approval of the fee letter. You want us to go ahead and approve that now too, Skip?
Well, we don't have a fee letter. I think as long as it's just $250 an hour, then I think we should approve that now.
Yeah, we approve it at a rate of $250 an hour, and no advanced fees are due.
I'll second that.
Rita?
Commissioner Stanley?
Yes.
Commissioner White?
Yes.
Commissioner Orthwein?
Yes.
Commissioner Ganger?
Yes.
Mayor Morgan?
Yes. Good. Okay, the next item is another recommendation by town attorney for our consideration. We have other counsel who can be brought in online. Should we try that now, Kelly? See if we can get Mr. Richmond?
Yes, I have one too, I guess. Joe Richmond? Hello, Mr. Richmond. I'm gonna pass you in, okay? Okay. You guys there? Yes. Okay. Mr. Richmond, are you there? Okay. Is everybody there?
Yes.
Yeah,
Okay.
Mr.
Hello,
Richmond.
Mr. Richmond on the line.
Thank you. Hello, Jerry. Mr. Mayor, Commissioners, you see the item on your agenda, consideration of filing RICO action and retaining special counsel to represent the town.
I would like to initiate this discussion by introducing Joanne O'Connor from my office, who has been the one that has been primarily involved in regard to defending the town, in regard to the several public records suits that have been filed against the town. And by way of background, before hearing from Mr. Richmond in regard to this, I would like to ask Joanne O'Connor, with your permission, to give us some background in regard to this matter, and then we'll hear from Mr. Richmond. Please, thank you, Ms. O'Connor.
Okay. Thanks, everyone. I wanted to go ahead and introduce myself, Joanne O'Connor with Jones Foster. I'm a partner, a litigation partner with the firm, and to bring you up to date on the status of the public records suits and the public records requests that have been made to the town. And I'm going to focus in terms of the public records requests on the 13 months that have passed since the end of August 27, 2013, because we have a good log of how many requests have been made. So more than 1,500 public records requests have been made to the town since August 27, 2013. We have good reason to believe that the substantial, overwhelming majority of those requests have been made by two residents of the town, Christopher O'Hare and Martin O'Boyle, and/or entities with which they're affiliated. Specifically, more than 400 public records requests have been made by Mr. O'Hare in his name individually. We believe another 300 have been made by Mr. O'Hare using fictitious names and email addresses, including some on which he's sued the town related to those requests. Another several hundred more have been made by Mr. O'Boyle and entities with which he's affiliated, at least as indicated by records available through the Florida Department of State. The requests have been prolific, and they have barraged your town staff. For example, Mr. O'Hare on October 8th, 2013 made 89 public records requests in one day alone. There was another day in September 2013 on a Sunday when Mr. O'Hare made 40 public records requests to the town over a 4-hour time period. Out of these public records requests, they've resulted in 36 public record suits that have been filed by Mr. O'Hare, Mr. O'Boyle, or entities affiliated with Mr. O'Boyle. 3 of those suits have been dismissed, and 33 lawsuits are pending. And in your packet, you have a listing of all of the public record suits that have been filed. So you'll see there's 36 public record suits that have been filed. 2 of those were voluntarily dismissed by Mr. O'Hare. 1 was voluntarily dismissed by an entity called the Citizens Awareness Foundation, which Mr. O'Boyle has testified is an entity that is funded by him. And 33 of those lawsuits are pending, and we've indicated which ones are pending and which have been dismissed. So of those lawsuits, 20 are brought by Mr. O'Hare. And again, I mentioned this series of public records requests Mr. O'Hare made on a single Sunday back in September. 7 of those lawsuits relate to requests that were made on that one Sunday back on September 29th. So we have 20 suits filed by Mr. O'Hare. There's 1 suit filed by Mr. O'Boyle and Mr. O'Hare that relates to public records requests and purported sunshine law violations. There's also about a dozen lawsuits filed by Mr. O'Boyle or entities with which he's affiliated. And in fact, in a recent lawsuit filed by Mr. O'Boyle against Mayor Morgan and special counsel Mr. Sweetapple and the town, Mr. O'Boyle avers that he's currently engaged in 12 lawsuits against the town regarding violations of public records requests. Just to address the costs that have been incurred by the town in responding to these public records lawsuits, since January 2014, the town has spent, well, let me explain how my firm tracks. So we have a general matter that we track sort of all general advice and counsel that's being provided to the town. And then we also have specific matters for each individual lawsuit. So for these specific lawsuits, since January 2014, the town has spent approximately $220,000, or an average of $24,000 per month. There's related costs such that the total expenses the town has spent on counsel at my firm since January 2014 is $370,000. So that would include expenses associated with these lawsuits, and also our office working with Kelly Avery and others in your staff and helping to navigate the Public Records Act in determining, and I could provide examples if you'd like, of the types of public records requests that have come in. They're extremely broad. There's been requests, for example, from an entity affiliated with Mr. O'Boyle related to your employees' employment applications, their home addresses, their prior employment, personal phone numbers, that sort of thing. And then some very, very broad requests that often require assistance in terms of navigating. In addition to the litigation costs, just the costs incurred associated with your staff time in responding to all of these public records requests. Mr. O'Boyle has been deposed in one of these lawsuits. He was deposed about 2 weeks ago on September 15th for approximately 8 hours. His deposition did not conclude and will be continued. That's all I have. Oh, and just one other thing. In addition to the public records lawsuits listed, that I've listed for you, you'll see there's 8 other cases that have been filed against the town by Mr. O'Hare and Mr. O'Boyle in the past 9 months or so. One of those suits has been dismissed. Insurance counsel is handling all but one of those cases, and again, there's 2 recent cases. One is a slander case that's been filed against the town, Mayor Morgan, Special Counsel Sweet Apple by Mr. O'Boyle, and another is a case that Mr. O'Boyle has filed against Chief Ward, Mr. Thrasher, and the town relating to an incident that occurred a week or 2 ago when he came in to physically make a public records request. So those are additional cases that, for the most part, insurance counsel is handling.
It's important to note in that regard that the public records lawsuits are not covered by our liability insurance company, and therefore we must pay counsel from the town's reserves. Any other questions of Ms. O'Connor?
Going forward, you have, I think, before you a copy of the curricula vitae of Jerry Richmond, and he is, as you have heard, on the phone. So if you would like to hear from him briefly in regard to the action that is proposed, we can do so now and ask him any questions that you might have.
Yes, Mr. Richmond, Mayor Morgan here. We're considering filing of a RICO action and retaining your firm as special counsel. We have a copy of your curriculum vitae, and I would like you to just introduce yourself and describe for you your review and opinions regarding the town advancing this action.
Sure. By way of brief background, I think you've got the CV. Everybody's had a chance to review that. I won't go into detail on that other than to highlight that I was past president of the Florida Bar, and I am a very active trial lawyer. And I've been involved in RICO cases. It is my opinion that the best way to counteract what the town is going through is to file
Mr. Richmond, what sort of damages can be obtained through the filing of a RICO action?
RICO action provides for, if you're successful, it provides for attorney's fees and triple damages that you would be able to recover. In this case, the damages you would be seeking would be damages relating to the cost and expense of defending all of these spurious actions as part of a racketeering enterprise. Also, there's a possibility that the action could include other municipalities joining in as well, and possibly supporting the expense of the litigation, but we can't count on that until and if there are others willing to go ahead and join us. So initially, the town would have to bear the expense of going forward. We are hopeful to get other organizations such as the League of Cities and others involved, but I don't want to tell the commission that we're necessarily going to be able to get any significant support from the outside until and if the case moves forward and appears to be successful.
So Gulfstream would be representing a class action? Is that what you're
That's the
describing?
plan, is that we would go ahead and have Gulfstream as to be the primary plaintiff. You only really need one plaintiff for a class action. You can have others, but you just have to have one plaintiff that qualifies as a class representative. Gulfstream would clearly qualify as long as it's willing to go forward with the action.
And what would your fee schedule be to handle this litigation?
What we have proposed is a partial contingency agreement, and my law firm is willing to go either way. The customary rates of my law firm range from $250 an hour to $750 an hour, and we would be willing to go forward on either a 2/3 of our hourly rate with a 25% contingency, or 50% of our rate with a 35% contingency. And the big point I would emphasize is that we don't take cases on a contingent or partially contingent basis unless we believe that the case has merit and a reasonable chance of being successful, or which could be a substantial amount of damages to be recovered.
Any questions for Mr. Richmond regarding his description of the case, the attorney's fees, or his recommendation of this action?
I just have a general question. Mr. Mayor, you can chime in as well. The gentleman on the phone is, with there are costs involved with the litigation in addition to what we would call an attorney's fees. Can anybody kind of generally expound on that when if we move forward with something of this type of scope, size?
Mr. Richmond, you described the hourly rate reduction with contingent fee at the conclusion of the case, but in addition to that, there are costs associated with advancing a case, from filing fees to deposition transcript, expert witness fees, etc. How would those be handled?
Well, obviously, the client bears the cost, but in terms of what it would cost, I think the main thing you're talking about in federal court, at least initially, aside from filing fees, eventually you're going to get into depositions if the case goes forward. So there would be customary cost of litigation relating to depositions, the work of propounding interrogatories, things like that would all be part of what's involved in the
just to summarize then, your hourly rate and the contingent fee would be in addition to the costs that the town would advance, I expect, on a monthly billing period?
Correct.
Is there any estimated, I know you can't because it's hourly, is there any estimated cost of how much these have cost, you know, how much something like this would cost overall?
There's no way at this point to predict how much it's going to cost overall or how vigorously the fence is going to be involved. And by the way, as an aside, I won't mention names, but I got a phone call last week from a prominent lawyer wanting to refer a case to me where he said that the person on the other side, or the person I would be representing, was very difficult to deal with and very wealthy. And was I interested? And when I asked the name, it was Martin O'Boyle. So Mr. O'Boyle apparently is reaching around trying to find prominent lawyers to go ahead and represent him. Of course, I quickly explained that I was not in a position to represent Mr. O'Boyle. But to answer your question more directly, it's very difficult to estimate. I would think you would be expending, even on the reduced hourly rate, somewhere in the range of $20,000 to $25,000 in fees the first few months of litigation. But beyond that, I can't really be more specific because it's hard to say what the other side may or may not be doing. But in terms of what we'd be doing, we'd be spending our efforts in the first couple of months. Number one, going ahead and gathering the facts and drafting the complaint, appropriate discovery, and preparing for a class certification motion and hearing.
But-
It's also possible there could be depositions early, but that's something over which we wouldn't have a great deal of control. But it wouldn't be our intention at this time to initially go ahead with any major deposition costs. We want to focus on getting the complaint properly drafted and filed at the earliest possible time.
And just to clarify, the public records lawsuits that we are defending do not provide for recovery of attorney's fees should we, as the town defendant, prevail. But the RICO action does. Is that correct?
That's correct. Prevailing party would get attorney's fees in addition to provable triple damages.
Tom?
I'm in.
Yes. We received, when we sat down in the commission meeting this morning, a note, I guess you would call it, or a letter, which I've given to Ms. Taylor. Would you please read that into the record?
I will. It says, "Good morning. I hand this writing to you at the behest of Martin O'Boyle, who is out of town. Mr. O'Boyle wishes to address the agenda item titled Consideration of Filing RICO Action and Retaining Special Counsel to represent the town. For those of you who are not familiar with RICO actions, the costs for such actions have been known to run into the millions of dollars. Mr. O'Boyle assumes that he, along with his associates, is the recipients of this proposed RICO action. In connection with the proposed RICO action, Mr. O'Boyle wishes to provide the Commission with a warning that any such launch will be met with an unfriendly response. Mr. O'Boyle reminds the Commission that the mayor has been inviting a fight for some time now. Mr. O'Boyle further reminds the Commissioners that should they decide to embark upon and support the mayor's grand battle, the likely result will be the demise of Gulfstream. Mr. O'Boyle urges Gulfstream to file their planned RICO action as soon as possible, provided that they believe it is the proper thing to do, and remembering their fiduciary responsibility. In closing, Mr. O'Boyle wants all to know that he is waiting for the Commissioners to take action, and he wants all to be prepared for the strike which he will inflict, which may include, inter alia, a RICO action against the town and or all of its commissioners and manager."
Thank you. Any other questions of Mr. Richmond or Mr. Randolph or Ms. O'Connor?
A question for Mr. Richmond. From his experience, I know this is a hard question, but I understand that these cases take a long time. Could he give maybe a best and a worst case scenario of an idea of how long this case could stretch out?
That's extremely difficult. The fact of the matter is that very few lawsuits that are filed in civil court actually ultimately end up going to trial. Most cases end up getting settled somewhere along the line. But in terms of how long it would take, the federal courts generally move pretty quickly in terms of RICO actions and details relating to whether you properly pled a cause of action. So I would anticipate that in federal court, this case could move pretty quickly, a lot faster than some state court actions would move. The unknown is which of the several federal judges are ultimately going to get the case and how fast they move their docket. The federal courts are fairly quick most of them are fairly quick on moving their dockets. So that's the best I can tell you. I can't anticipate whether this thing is going to take months or take a year or more until we see how it goes. In terms of Mr. O'Boyle's statement that he's going to file a RICO action, that's something we have to deal with when we get there. I don't see any basis for it, but that's the only comment I can make on that since I haven't seen what it is he's threatening to go ahead and file.
Thank you.
I hope that answers your question, but it's very difficult to be
I know, it's a difficult question, I understand.
who the judge is and see how the case is going. That's one of the big problems in litigation is being able to accurately budget, particularly at the inception of a case.
Well, in my opinion, the town of Gulfstream has suffered enough. This is a town that has been expending funds and time and resources and morale and the difficulties of retaining and hiring employees as a result of the scandalously malicious and frivolous lawsuits and public records requests filed by Mr. O'Hare and Mr. O'Boyle and the related entities. And I think it's time for the madness to stop. Is there a motion on the recommendation by council?
I have a comment before you move forward. In the event you were to move forward, do you want to specify which financial arrangement you would make? There were two options that were presented.
If that needs to be decided here, I guess it could. My recommendation would be that we reduce the hourly rate as much as possible because of the unseen nature of those costs. So I would recommend a 50% hourly rate with a higher 35% contingent fee award.
I agree with that, just because of the amount of hours it takes. I think that's a more prudent way to go forward.
Donna? Tom?
You have more experience in this end that I do, so I could.
Seems to me we want to keep the costs down as much as possible
That would
as
be
we're
the
advancing
main-
the case, knowing these costs will come back when we prevail in the case. But it seems to me it would be prudent to go with the lower rate and plus give incentive to counsel
Right.
to advance this case to a conclusion, knowing that 35% contingent fee is a significant amount of money. I would like that as an incentive for our counsel.
I agree with that.
Your secondary policy decision would be, obviously, after lowering the upfront cost by the hourly rate, would be not only is the objective to get damages and recovery, but also to cease expenditures on current actions.
That's correct. I think as has been discussed today, we can either take the approach of defending these individual cases as they come in and bleed to death by 1,000 cuts, or we can take steps necessary to stop those cases by advancing this case which shows, from the evidence that I've seen to date, a conspiracy of sorts to advance actions that essentially do nothing other than shake down municipal agencies and related contractors for funds. And that all the talk of open public access, white knights on chargers helping the common man is nonsense. This has all been about money. And by putting a stop to it with this RICO action, we then put a stop to the individual lawsuits on the public records request. I'm confident that would be the result of this case.
I agree, because I don't see an end just defending one by one. I think we have to take it all as a group and go forward, because just defending is not doing anything. I think we tried to settle with the individual once, and I think that it's very important that we just don't bleed to death. We protect ourselves.
And that experience with the settlement is largely driving this, I believe, which is we saw what happened
Yeah.
when this town tried to work reasonably with the parties, and what happened is we're right back in the middle of it, and it's time for it to stop. So, anything else we need to cover, Mr. Randolph?
No, as long as you've finished your discussion, you're ready to go forward.
Any other questions or comments?
Mr. Chairman, may I comment for a moment?
You may, Mr. O'Hare.
I understand that the purpose of the RICO is to get rid of the public record request. And I have a question regarding the RICO. Mr. Richmond, I'm sure, is a great attorney. He's certainly well respected. Indicates that I'm going to be indicted in this RICO action. But 3 months ago, Mr. Sweetapple said to my lawyer, if you dismiss all your charges, we won't include you in this RICO action. So I understand what the purpose of this is, and it's really to get rid of all the other complaints. I've been in litigation. I hate it. It's expensive. You get bills every month for $50,000, $100,000. This, because I am innocent, will actually go to a jury trial. Now, Mr. Richmond has been very careful not to tell you what that'll cost, even though I think Commissioner White asked him, what's it going to cost on the downside? We didn't get an answer, but I can tell you what it's going to cost. Bills when these lawyers all get together and spend 22 hours preparing for trial each day, you're going to get bills of $100,000, $200,000 a month. The time the trial actually takes place. And then, of course, there'll probably be a settlement just before the jury. You're going to spend $50,000 just on voir dire, just selecting jurors that you hope are going to be favorable to your case. You're talking about millions of dollars. And it's not your money, it's their money. So many of these cases could be resolved by just admitting guilt, paying the attorney's fees. A typical public records case settles for, what was Joel Chandler's? It was $1,500 to make him go away. And yet you spend $20,000 saying, no, we're not guilty and we're not going to cooperate. That's just not a good use of public money. If you make a mistake, eventually a judge is going to say you made a mistake. Give them the record, pay their attorney's fees, and let's go on to the next thing. But instead you spend piles and piles of public money, and this is another example. I bet you $5 million from now, this is still going on. It's just a shame. I like this town. Maybe this is my attempt to try to steer you in the right direction. Maybe it's gotten a little out of hand, but my God, this town's going to be destroyed.
Why don't you move?
I'm sorry, ma'am. What's your name?
Oh, we don't get into colloquy back and forth between residents, but we certainly appreciate your comments and your advice, Mr. O'Hare.
I really think you need to reconsider. Thank you.
Mr. Mayor,
Anyone
may we
else?
also speak?
Yes, sir, Mr. Graziano.
I don't usually agree with what Mr. O'Hare said, but he did say something with which I fully agree. It is our money, and we would like you to spend it fighting these gentlemen. Thank you.
Anyone else? If not, we'll consider a motion. Tom, why don't you
So our fee arrangement was, proposal was 50% reduction in hourly rate of 35%.
35, yeah, contingency.
Contingency. So I'll be formalized at a later date and for our motion. So make a motion to retain special counsel, Richmond and Greer, PA, specifically Gerald F. Richmond, based on a fee structure of a 50% reduction of the standard hourly rates with a 35% contingency fee on any recovery.
I second that.
Read it.
Commissioner Stanley?
Yes.
Commissioner White?
Yes.
Commissioner Arthwine?
Yes.
Commissioner Ganger?
Yes.
Mayor Morgan?
Yes. Thank you. And thank you, Mr. Richmond.
Thank you all.
Anything else from the town attorney?
No, nothing further. Thank you.
Let's move on to item 9, which is reports. Mr. Brandon.
Andy Brandon Gillespie, reporting on the progress of the undergrounding project. As of the end of today, we should have all the resident services, the tennis club services, the golf services, all on the new underground system. We will retain the street lighting in an operational mode until such time that FPL comes and removes the poles. We have not had any major expenses since the last report. We have placed a new progress map on the board outside, which hopefully by the end of today will be totally green and totally in service on the underground system.
And service on what did you say? The last one you said?
Underground system.
In service on the underground system.
Thank you.
Beyond this point, we will be engaged in doing any repairs we need to for landscaping that the contractor has need to go back in and fix that they've damaged. Any concrete or asphalt work that needs to be done. We have a couple places that we have to pour a little concrete. We have some asphalt street work that we go in and do the repairs, and those will be done. We're doing the as-built construction drawing, finalizing those, along with as-built surveys that we have to turn into the power company. Over the next 30 days, those will be completed and the contract will be finished. The power company continues to tell me that we should be getting their new information on the north half by the end of this month.
Any other questions, Mr. Brandon? Thank you for the update.
Thank you.
Town manager report included in our packet. Do you have anything to add to it, Mr. Thrasher?
I have nothing to add to it, no.
Any questions, Mr. Thrasher? We'll accept that as submitted. Next ARPP meeting is October 23rd. Look forward to reading the minutes from that meeting. Financial report and water usage report. Anything to add to that which is included in our packet, Mr. Thrasher?
Nothing to add.
If no questions, we'll accept that as submitted as well. Chief Ward.
I request that the activity report for September be accepted as
Accept that as submitted. Any items by the commissioners? Comments, questions, points of order?
I don't have anything, Mayor.
I don't either.
If not, meeting is closed.
Thank you.
Thank you.
Thank you. Thanks, Bill. Thanks, Bob.